All right. So it gives me great pleasure to introduce the next chairperson and the next panel, which is on universal jurisdiction, lessons from the past and current application. A subject or topic that's very close to my heart, since it's one of my research areas. So this panel is chaired and organised by Lennart Poulsen. So Lennart is a highly regarded international criminal law barrister. He is based in the chambers of Stephen Kay, QC, at 9 Bedford Row, and he's many years' experience before international courts and tribunals. He's represented clients in several high-profile international cases before various international tribunals, and he's advised foreign governments, non-state entities, international NGOs, and individuals on all aspects of international criminal law and international humanitarian law. Lennart regularly contributes to legal discussions and speaking events and has published several articles in international media on various aspects of international law. So with great pleasure, I introduce the next panel and the next chairperson. So over to you, Lennart.
Thank you very much, Amina. Hello, everyone, and welcome to this panel. Thank you for joining. It will be as interesting as it promises to be. It's going to be on the topic of universal jurisdiction, of course, how it's evolved from the Second World War and the Nuremberg trials, and what the key challenges facing universal jurisdiction are today as it fans out into various domestic courts around the world. It's an interesting area because it allows for an international crime to be prosecuted in a domestic court, which means that criminal practitioners everywhere might appear in such a case in their own country's court in the course of their career. And like with most things in international criminal law, it's not without its challenges and controversies. It has, over the last few years, gained a lot of attention, with more cases being undertaken under universal jurisdiction in different countries, especially in Europe, countries like Belgium and Spain, Germany, Netherlands. So the image of international criminal law being something that takes place only in The Hague is no longer the case. I am joined by a stellar panel today. It's a smaller panel than what we had envisaged, so it means I've had to ask each of them to speak a little bit longer than I otherwise would, but that's our game. And I'd invite you to listen because they will undoubtedly provide their own fascinating insights and nuggets of wisdom in what is a quite fascinating area and an evolving one. I'm not going to be able to do justice to their respective CVs and backgrounds here, so I recommend you look them up and read about them, as they are all very impressive. Can I just check that they are with us? The first panelist is Professor Olympia Becker. Olympia, are you with us? She is. Hi, Olympia. Brilliant. Olympia is Professor of Public International Law, head of the law school at the University of Nottingham. She has a lot of experience in working with international criminal justice institutions, the European Union, the EU Genocide Network, for example. She is a recognized trainer in things like capacity building, judicial training, bilateral assistance, and has a lot of experience in post-conflict situations, as well as legislative drafting for different countries. She's contributed to the work of the International Law Commission on the drafting of the Crimes Against Humanity Convention and to the multi-state negotiations of the Mutual Legal Assistance Treaty. Our second panelist is Tatiana Eatwell. I believe Tatiana is here as well. She is. Hi, Tatiana. Tatiana is a barrister at Doughty Street Chambers. She has a PhD in public international law from Cambridge, and she advises individuals, states, NGOs on a wide range of public international law and international human rights law. She often appears before the UK Supreme Court concerning interpretation of international law, for example, in crimes and terrorism and war crimes and torture. And she appeared recently as a junior counsel in a quite famous case now of Reeves Taylor. And no doubt we will be asking her about that case later on. This was obviously concerning a definition of torture and its application to non-state armed groups participating in non-international armed conflicts. Our third and final panelist is Marie OLeary, and I can see Marie is here with us as well. Marie is a counsel for the Office of Public Counsel for the Defense in the International Criminal Court in The Hague. Prior to working at the ICC, she worked for civil defense teams at the International Criminal Tribunal for the former Yugoslavia. She was formerly employed as the head of office of the Association of Defense Counsel and currently serves as its elected president. And she also contributes to forum discussion publications on defense and international criminal law, and also gives lectures as a guest lecturer at various universities. There's a lot more I could say about each of them, but I will stop here. And once they've all spoken, I will open the floor for questions. If I may, I will now ask Olympia to start us off.
Thank you very much, Lennart. It gives me a great pleasure to be joining this conference today. It's lovely to see old friends and new participating. I'm really sorry I haven't been able to follow from the start of the day. I've been teaching all morning, so I've only joined you after lunch. So apologies if what I'm about to say may have been raised already by other colleagues is where I'm going to with that. So universal jurisdiction, as you know, is a form of extraterritorial jurisdiction exercised by a state over acts which have taken place outside its territory, based on the nature of the crime. It has already been discussed. So in examining the evolution of universal jurisdiction since the Second World War and the UNWCC, it is fair to say that states have previously applied the principle of universal jurisdiction sparingly. So reasons for that include extraterritorial crimes being a lower priority, as well as political concerns around investigating nationals of other states, especially where the suspect was high profile. There have also been some legal limitations, such as the suspect must be present in the territory of a state exercising jurisdiction. Despite this, the extraordinary African chambers established in the courts of Senegal convicted the former president of Chad, Hissène Habré, for international crimes on the basis of universal jurisdiction. I consider this a pivotal moment in rekindling the interest in universal jurisdiction, and the current discussions of creating a potential tribunal for Syria based on the pooling of universal jurisdiction has been described as the new Nuremberg moment. Now, it's fair to say that universal jurisdiction has seen a surge in recent years, predominantly, as Lennart has already mentioned, in Europe, on the European continent. And I think this is a response to the situations in Syria and Iraq, which so far have been unaddressed by the international by an international judicial mechanism. The large number of people fleeing Syria, Iraq, and Afghanistan have led to people seeking refuge within the European borders, including victims who are now able to bring cases and suspects who are within the reach of European judicial authorities. It's often victims and victim communities who have a large role to play in building a case in relation to universal jurisdiction through identifying suspects, bringing complaints, and assisting with evidence gathering. You may have seen the report that the Trial International does every year, the Universal Jurisdiction Annual Review. In my view, a very useful review of universal jurisdiction cases. If you haven't looked at it, it's very interesting to see. They tried to map what has happened through the COVID-19 pandemic. And thankfully, universal jurisdiction cases have not stopped despite the pandemic. So by the end of 2020, there were approximately 144 suspects under investigation in 18 countries, pertaining to 21 different states. And the charges go from genocide, crimes against humanity, war crimes, and torture. Many charges have been brought. So to answer the question we have been set as to whether universal jurisdiction is a viable way of prosecuting international crimes where domestic criminal justice systems and laws can be dramatically different, I would argue sometimes using universal jurisdiction is the only option we have. And operating in different systems with lack of coherence and consistency may be a price worth paying. So when faced with accountability in the aftermath of mass atrocity, like at the time of the UNWCC, the solutions are hardly simple. I shall try to illustrate some of the challenges that I see faced by the quest to bring justice through universal jurisdiction, with a brief discussion of some cases pertaining to Liberia. So Liberia is an often overlooked state, is a good example to highlight the prospects, but mostly the challenges associated with the pursuit of justice for international crimes. We've had some recently completed cases, and Lennart mentioned the Agnes Reeves-Taylor case, which was discontinued in the UK, but also in Europe and the US, which I think exemplify the need for an international effort. And they also provide a stark contrast to the lack of accountability provided for Liberians at home. Before I continue, I need to disclose that I'm also a member of the board of a Swiss-based NGO called Civitas Maxima, who bring cases on behalf of victims of war crimes, crimes against humanity before suitable fora. So within this role, I've been intimately involved in some of the cases I will be talking about today, but of course, I'm speaking today in my personal capacity, and my views do not necessarily represent Civitas Maxima. So going back to Liberia, for Liberians, the increasing use of universal jurisdiction means that other states are bringing cases which include charges of atrocity crimes. States have most often pursued universal jurisdiction cases related to Liberia when the accused are present on their territories. While states can technically bring such cases without a link to the accused, such a pure form of universal jurisdiction is nowadays rare. So one such case is that of Aliou Kosaya, who was arrested in Switzerland in 2014. His trial took place pursuant to the 2011 Swiss law, which allows for universal jurisdiction for international crimes. Kosaya has been accused of crimes committed during the First Liberian War. The trial is a landmark case, not least because it is the first Liberian national to be tried for war crimes in relation to the civil wars. Although the first alleged Liberian perpetrator to be charged in Europe for crimes under international law was Martina Johnson, but her case is still awaiting trial in Belgium. So the Kosaya case is also landmark for Switzerland, as this was the first time that the Swiss Federal Criminal Court has held a war crimes trial. However, universal jurisdiction cases present their own set of challenges, which is what I would want to focus on next. It is harder to successfully investigate and prosecute crimes when you're far away from the evidence, when the crime scenes and witnesses are in another state or on another continent. The collection of evidence to assist the trial is crucial for its success. It is not easy for national authorities exercising extraterritorial jurisdiction to collect such evidence in post-conflict states. They may be refused access both to evidence and to the country itself. They may not speak the language or understand the cultural context, and they may be trying to conduct an investigation many years after the crimes have taken place. Therefore, it is often not an option for foreign authorities to collect evidence in such extraterritorial cases. Well, obviously, the use of new technologies, which is something very different to what we had in UNWCC, such as video link, may help in that respect, although it is not often easy to arrange. Moreover, evidence collection requires certain experience and expertise that most national authorities in post-conflict settings understandably lack. Documenting atrocities in a comprehensive and systematic manner is crucial, in my view, for the success of any trial, irrespective of the forum in which the trial is going to take place. For Liberians, arrests and cases conducted in other states have now provided demonstrable cooperation between the Liberian authorities and foreign jurisdictions on the issues of justice. In another case, the case of Kundi who was arrested in France in 2018. Authorities suspected the accused of crimes against humanity and torture allegedly committed during the First Liberian Civil War. French and Liberian authorities collaborated to conduct related fact-finding activities in Lofa country in the northern part of Liberia. In fact, all of the Liberian cases require national investigators to travel to Liberia and other states where evidence exists really, to speak to victims and witnesses. Obviously, this can only happen through a commission rogatoire, but there has been no guarantee as to the Liberian authorities that they would always react positively to a request like that. In practice, this means that much of the evidence is likely to come from sources either outside Liberia or it is provided by local NGOs. Contextual problems also arise, just the lack of paper trail for the Liberian armed conflicts, which coupled with the relatively low life expectancy adds additional pressure to act whilst victims and witnesses are still alive. Linked to are numerous challenges with regard to witnesses. Many of the Liberian witnesses who testify in those cases abroad never left their village before, never had a passport, never appeared before a court, let alone a white person's, nor would they be entitled to any form of protection when they return to Liberia after testimony. Witness relocation does not normally happen with regard to cases going before national courts, before a foreign state. In response to issues around evidence, including the need to hear testimony from witnesses based in Liberia, the Finnish authorities have taken an innovative approach to proceedings in the case of Jibril Masakwi. In the process, they have also provided the most obvious demonstration of cooperative activity by the Liberian authorities with foreign jurisdictions. So Masakwi is a Sierra Leonean national who was residing in and arrested in Finland. He stood accused of committing war crimes and crimes against humanity in Liberia and Sierra Leone. To facilitate a greater number of witness testimonies, the trial was partially held in Liberia. The arrival of a Finnish court, the Finnish courtroom onto Liberian soil in February 2021 provided a significant moment for victims. Indeed, extraterritorial trials do not operate in a vacuum. Although the integrity of the process before a forum where it takes place needs to be respected, the social and political ramifications of such trials cannot be ignored. The Masakwi trial has reinvigorated domestic calls for a Liberian war crimes court, and I caught a bit of the discussion in the last panel I was at, in panel E, about, should we create more courts like that? Collectively, the arrests and cases being conducted and which have already been conducted by foreign jurisdictions have all had an impact on Liberia. In particular, they have sort of spurred a public hope for justice. And as we await the outcomes of the Swiss and the Finnish proceedings in the trials of Kushaya and Masakwi, respectively, I think it is an opportune moment to consider yet another challenge. While the principle of universal jurisdiction is an important tool in the fight against impunity, the focus on domestic security means prosecutions have increasingly been brought under anti-terrorism legislation, either as standalone charges or with cumulative charging for core international crimes. In this respect, it is fundamental that international crimes are fully represented, the nature of the acts which have taken place is revealed, and that appropriate penalties are applied. Accordingly, where prosecutors are taking place under immigration or anti-terrorism charges, it is essential to use tools such as cumulative charging wherever possible in order to bring justice to the victims of core international crimes. Universal jurisdiction trials, that is trials outside the country where crimes have occurred, come with a number of expectations and challenges. I'm not therefore arguing that they should not take place. However, I cannot disregard that doing justice remotely might be too far removed for the victims, as the message of proceedings taking place abroad may not reach them easily, but also for the truth, which is necessarily and perhaps differently sought before a national court, as well as the public appetite for the host country. Outreach has been a massive challenge for all international criminal courts and tribunals. A national court prosecuting crimes committed abroad does not have an outreach mandate or indeed interest to engage in outreach in the country where the atrocities have taken place. Getting the message across to those it concerns is and will be problematic. On the truth front, truth is relative to the evidence at hand. A single national trial abroad is unlikely to focus on a broader, contextualized, or indeed publicized truth. Finally, from my very limited experience of following some of the universal jurisdiction cases that took place here in the UK before UK courts, the public galleries are empty and the jurors, where present, are totally disconnected from the narrative. The average person's experience is far removed from understanding or indeed caring about international crimes. That said, universal jurisdiction cases remain, in some instances, such as cases arising out of my Liberian example, the only avenue for doing justice. And this is, if you like, where the greatest legacy of the UNWCC and subsequent use of universal jurisdiction lies. So, what are the options for post-conflict justice, having considered the Liberian experience? Watching the prosecutions by other states, which are also predominantly taking place abroad, has shown a spotlight on the fact that justice is still not happening within Liberia. Whilst the extraterritorial cases can provide some measure of justice by themselves, they're not enough. Allowing impunity to continue within a state where atrocities have happened hinders reconciliation, prevents victims accessing reparations, and exacerbates issues such as corruption. Consider, if you will, ongoing situations of impunity such as Syria, Myanmar, and Ethiopia. The reality is that barriers to justice continue to exist in many operational contexts, and they will not be overcome easily. Whilst providing accountability is vital in all situations, resources are finite, and there are other challenges which may be considered a priority both by domestic governments and by the international community as a whole. These now include not only an increasing number of situations of concern, I've mentioned Myanmar and Syria, but also wider concerns, such as the need for a continued response and recovery efforts owing to the global coronavirus pandemic. So in terms of universal jurisdiction, I'd say the fight is not over, but we still need to continue the good fight. Thank you.
Lennart, your microphone is on mute.
Sorry. Olympia, thank you very much. That was fascinating. I was going to say that many people will no doubt have a lot of questions for you. I know I have a few, but I think we'll deal with the questions all together at the end. So if we could now turn to Tatiana.
Yes, thank you, Lennart, and thank you so much for convening this panel and to all the organisers of this event today. Like Professor Beku, unfortunately, I haven't been able to follow the whole event, so I come from a place of near ignorance with respect to what has been said this morning. Professor Beku is a tough act to follow, and I agree with much of what she said, so there we go, my job is done. But we've been asked to address really 4 questions in our presentations today, which Professor Beku has addressed with in great detail and with aplomb. Firstly, to provide our own views on universal jurisdiction and how it's evolved from its use and function during World War II, and with respect to the war crimes commissions up to now. What are some of the key challenges of universal jurisdiction? How might these be overcome? Is universal jurisdiction a viable way of prosecuting international crimes? where domestic criminal justice systems and laws can be dramatically different? And finally, how does universal jurisdiction ensure a consistent standard of trial, transparency and judgments across different legal systems? Now, Professor Beku has covered quite a lot of what I was going to cover about the key challenges to universal jurisdiction. So I think I'll focus and I'll concentrate on the questions 3 and 4, but much of what I say is very much interlinked. So I will give it a start and just run over the obstacles to avoid repetition of what already has been said. But my view is that universal jurisdiction is an important means of ensuring that individuals responsible for atrocity crimes are investigated and prosecuted for those crimes in circumstances where, for whatever reason, the state in which those crimes were committed is unwilling or unable to do so. I do not think, in my view, that it's the only means of filling the impunity gap or to ensuring accountability. And when I say that, I'm saying, generally speaking, I do not think criminal justice is the only means of filling the impunity gap and ensuring accountability. But it's nevertheless an important tool. And from what I know and understand of the War Crimes Commission's work, that work is an important early example of the principle that the primary obligation to investigate and prosecute is on states. It's not on international tribunals. And it was the War Crimes Commission work is an important example of the international community supporting states in the investigation and prosecution of war crimes. Forgive me if I've got that wrong. Have a universal jurisdiction, as Professor Beku has mapped out, is not without its difficulties. And although one of those is generally accepted in scholarship and in public discourse generally, that genocide, crimes against humanity are universal jurisdiction crimes, there is the Genocide Convention itself doesn't provide that states must legislate to make genocide a universal jurisdiction crime. And that leads to one of the key challenges, as I see it, for universal jurisdiction. That is the challenge of states implementing legislation providing for universal jurisdiction over atrocity crimes. Many states have, and those examples we can see, Argentina, Germany, the Netherlands, Belgium, to some extent, of providing for universal jurisdiction over certain crimes. The United Kingdom, however, has kept very much close to its obligations under the relevant international conventions. And in that respect, torture, as defined under the Torture Convention, is essentially the only pure universal jurisdiction crime in the United Kingdom's domestic criminal law. With respect to genocide, our courts have jurisdiction over the offences committed abroad only if they're committed by British citizens or persons resident in the United Kingdom or under the United Kingdom's service jurisdiction. So there is some disconnect between what we understand universal jurisdiction crimes to be, and in many states, the domestic legislation of those states providing the courts with the competence to exert jurisdictions over those crimes. A second obstacle, and that's interlinked, is there's somewhat little appetite amongst states to investigate and prosecute crimes that have been committed abroad by non-citizens against non-citizens. That appetite is increasing slightly in recent years, as Professor Beku pointed out, with respect to probably influenced by the conflicts in Syria and Iraq, and the finding that many people, victims and alleged perpetrators, are now found on the territory of European states. But given the nature of the increasing number of situations, and one would think the exponentially increasing number of alleged perpetrators, the number of investigations is particularly low. An exception, I would say, in terms of appetite, and an interesting one, was with respect to the crime of piracy. Because when we talk about universal jurisdiction crimes, we're often thinking of atrocity crimes. But you may recall that about 10 years ago, maybe more, there was a spate of piracy off the coast of Somalia. And in that case, the international community rallied together very quickly and efficiently in order to organize the prosecution of persons who have allegedly committed piracy. And that didn't necessarily, those prosecutions didn't happen in Somalia. Those prosecutions happened in Kenya, in the Seychelles, and in Germany and the Netherlands. And what was quite extraordinary was that that was a situation where, with respect to Germany, I think it was maybe 7 or 8 they were boys, young men, were transported, extradited to Germany to face trial for the crime of piracy. And so that was, one might say, you might want to compare the international community's response to that to crimes committed essentially against shipping and the interests of shipping, and how enthusiastic the international community was to rally together in order to prosecute alleged suspects for those crimes, when you compare it with the appetite for prosecuting universal jurisdiction crimes, other crimes of universal jurisdiction. Another obstacle, I would say, with respect to legislation is the harmonization of definition of the crimes in domestic laws. And it's very much linked to states' failure to implement their obligations under international treaties, under the Torture Convention, and I would say under the Genocide Convention, but applying the customary international law principle that it is a crime of universal jurisdiction, either failing to express a specific requirement of the offence, so the offence is too narrowly defined, or providing for an overly broad definition of the offence in legislation, so it doesn't sufficiently capture the conduct that the crime is meant to catch. And in this respect, I refer to the Torture Convention that is directed specifically at crimes committed by public officials and persons acting in an official capacity because of the overriding impunity of persons who had committed torture as state actors, and impunity for state-sponsored torture. And in that respect, with overly broad definition that fails to identify the official perpetrator requirement, fails to capture the importance of prosecuting state officials for torture. Professor Becky mentioned investigation, the requirement for cooperation with other states to investigate crimes committed abroad, finding and locating witnesses, credible witnesses. Many people often focus on victim witnesses, witnesses for the prosecution. There's also difficulties with the defense to find and locate witnesses in support of the defense, especially when it's a question of historic crimes. You have an issue of language and interpretation potentially throughout trials, particularly if individuals are from a region that has a particular dialect and may not be able to follow proceedings particularly well from where they are. Evidence collection, the collection and documentation of evidence is extremely important at the time that the crimes are committed or near thereafter. And it's important that that evidence is collected and documented such that chains of custody is evident, that the evidence, should it be produced in trial, is admissible and not subject to inadmissibility criteria in domestic criminal laws. Professor Becky mentioned jurors being disconnected and not having first-hand involvement or experience over these crimes. But then one might argue that some jurors are also disconnected from the environments in which other serious crimes are committed and do take these prosecutions seriously, although I accept that they may not have much interest in crimes committed abroad. Finally, sentencing, and one problem that one might find is a disparity of sentencing across different criminal jurisdictions. And in a way, I would say that one of the ways to overcome these issues of legislation, definition, disparity of sentencing is international cooperation. And that is fundamental, I would say, to domestic prosecutions of universal jurisdiction crimes being successful. International cooperation is key. International agreement on the definition of crimes subject to universal jurisdiction and actual actioning and implementing the necessary legislation. So is universal jurisdiction a viable way of prosecuting international crimes where domestic criminal justice systems and laws can be dramatically different? Yes, I agree with Professor Beku that it's sometimes the only option. It's a valuable tool for the prosecution of these crimes, but linked with what I said above, it requires international cooperation and the harmonization of definitions of universal jurisdiction offences in the domestic legislation of each state, not just an international convention. And I think universal jurisdiction in this sense is important because, and supports the foundational principle upon which the international criminal justice system is based, and that's the principle of complementarity. The primary obligation is on states to investigate and prosecute these crimes, not the ICC as the International Tribunal. It is a court of last resort and is always intended to be. But finally, perhaps one of the most, well, perhaps not one of the most, but an interesting question is, how does universal jurisdiction ensure a consistent standard of trial, transparency and judgments across different legal systems? So universal jurisdiction does not ensure a consistent standard of trial. It is a principle of jurisdiction and whether or not the state has prescriptive and enforcement jurisdiction over specific offences. What can ensure a standard of consistency, a consistent standard of trial is international human rights law. Now, 173 states have ratified the International Covenant on Civil and Political Rights and thereby have guaranteed to, are under an obligation to guarantee the rights to fair trial. And it's these international human rights standards that ought to be the standards that provide for consistency and standards in fair trial. Transparency goes with that with respect to the requirement for the defendant's right to a public hearing. And with respect to judgments, again, that is a question of, there will be some difficulty, there will be disparity in terms of interpretation of law as you go in different jurisdictions. And it's an international cooperation, an international conversation that is important with respect to harmonization of these laws. So I would look to the general principles of international human rights law as universal standards of the rights to fair trial, presumption of innocence, and the right to a public hearing, that are those standards that ought to guarantee the standards of trial. One final comment from me, and that's with respect to the focus on criminal justice, with respect to the commission of atrocity crimes and individual criminal responsibility. And in my view, it's not the only means of achieving accountability for these atrocity crimes. And indeed, certainly in my work with respect to victims and victims' families, it is not the only means by which they see justice being achieved. And the prosecution of an individual doesn't necessarily provide the justice or accountability that they're looking for. And universal jurisdiction cannot provide justice and accountability to all of the victims of a particular atrocity. It will be an indictment concerning one or two victims, as we've seen in the trials in Germany, with respect to a specific perpetrator, and doesn't necessarily, these prosecutions don't necessarily capture the systematic nature of the crimes. And so in my view, this very much needs to go in parallel with a discussion about state responsibility for state involvement in either failing to prevent atrocity crimes or complicity in and commissioning in these kinds of crimes. And this really important discussion about universal jurisdiction and individual criminal responsibility should not deflect from the questions of state responsibility for their failure to comply with obligations under international law to prevent these crimes from being committed in the first place. On that note, thank you.
Tatiana, thank you so much. That was very, very interesting. I particularly found interesting your views and your comments on the application of universal jurisdiction in domestic legislation. So we'll get back to that in the Q&A. Our final panelist is Marie OLeary. Over to you, Marie.
Thank you, Lennart, and thank you to all of the organizers for having me here today to talk about a really fascinating topic, especially since it intersects with a lot of different parts of the work that we have before the International Criminal Court right now. I will say that none of my views are those of the International Criminal Court. They are mine today, so you're in luck because I have a lot of thoughts. Though I will say that I can second and third Dr. Beku and Ms. Atewell. Going third last on the last panel, I'm sure there's a lot today that has already been said, and I'm at least in the same boat as you ladies in that I also had to miss the morning, unfortunately, but I did catch some of that second session. So again, my apologies as well if I'm overlapping with things that were already discussed this morning. However, we were asked to talk about, of course, views on the evolution of universal jurisdiction and the UNWCC to now. Well, the obvious answer, of course, is that we're all pulled together by, the internet. Today we're looking at each other all over the place and able to share more readily, more quickly. Scientific advances have allowed us to connect faster, better. So there's that possibility that wasn't there at the time, the UNWCC. But maybe a less universal take, but maybe some of you agree, and maybe this was discussed, is how we come full circle. Because to me, the UNWCC, in supplementing international tribunals back then, is similar to the creation of the independent investigation missions that we're seeing developed and promulgated right now, whether we just talked about Syria, the IICI, the IIIM, UNITAD, all of these creations are now feeding into potential tribunals, potential courts, but definitely universal jurisdiction as far as cases that will be seen across the board in different jurisdictions. So it feels like a similar model, only a much more advanced, especially in technology. We also, and I don't know how much this was discussed, but are seeing private investigations that now come up into conflict zones. And in particular, I don't know if anybody's brought up like CIJA and the work that they're doing. If you go to their website, you can see that they're currently working in at least 13 different countries. And they have supported evidence that will go to universal jurisdiction cases that take place on their site. They'll talk about one that's in the Netherlands, one that's in Germany. So this is already going on as far as the different types of investigations that are out there. But the difference is, of course, other than technology, is that there's a wider pool of procedures that's been established at this time. The crimes themselves, substantively and procedurally, have been more developed in the cases. We have specialists. There are actual degrees now in international criminal law, transitional law, and transnational law that didn't exist even very, very recently. I had a student group telling me that one of the self-represented accused had a degree in law, but not in international criminal law the other day. And I was thinking, I don't have a degree in international criminal law because it simply wasn't looked at for a very long time. But the specialty has been built up, of course, in the work of the ad hocs, the courts, NGOs, domestic jurisdictions using universal jurisdiction that we didn't have before. And the ICC exists, of course. I promise these are not the ICC's views, but we're going to talk about the ICC a little bit, in that it's a rallying point, at least, if nothing else, for 123 states. That is maybe a point and a center point in looking at this as far as how we can exercise a more comprehensive view of universal jurisdiction. It's also different in what is the modern day definition of universal jurisdiction. And we just heard a little bit about, about piracy and about torture and about how there are these different crimes that are maybe being used a little bit differently. But also, what are we talking about? I was really happy to hear about different justice models, because I don't think international criminal prosecutions or just criminal prosecutions, which is the traditional definition of universal jurisdiction, of course, is the only way through this. We maybe need to look at universal jurisdiction as also encompassing commissions, reconciliation efforts, hybrid models, and the whole panoply of justice mechanisms that we see to this day. An important start of discussing this, of course, then, a viable way of prosecuting. Is it a viable way of prosecuting crimes? I would say yes, it's not only viable, but as complementarity was just addressed by Ms. Atewell, it's not just in existence, it's required by the Rome Statute, including universality principles. If we look to, I've brought a handy guide here of the Rome Statute. If we look to the preamble in itself, paragraph 6 right here says that it recalls the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. And if we go down towards the bottom, we see that the ICC emphasized that it was established and it shall be complementary to national criminal jurisdictions. As Ms. Atewell said, it is a court of last resort. It is not meant to take over, and universal jurisdiction actually has to be exercised to make sure that the ICC itself can work. It remains that primary obligation of the states. It's not just viable, it is obviously imperative, and this was highlighted even last week at the UN General Assembly. ICC President Judge Hopmansky actually spoke to the states, encouraged them in the complementarity principles, and said it again, it is a primary right and responsibility of those states to investigate and prosecute the crimes of the Rome Statute. This is simply because stronger national jurisdictions on international crimes, of course, means enhanced global rule of law, is what he said. The independent expert report, if anyone follows this at the ICC, also touched upon complementarity and positive complementarity, and really, to some degree, said to the prosecution, no, you don't necessarily have to do that watchdog function. Just let those other prosecutions go on at the same time as you're completing yours. And positive complementarity itself should be, quote, a welcome byproduct of the preliminary examination process of the court, rather than a result of a preconceived policy of the Office of the Prosecutor, said in its report. So it's looking at how is there this interaction between the ICC and the states themselves who want to exercise either through a tribunal or a body or in individual cases, and how does that work? And I think that's the point that we're at now in time. I had any number of NGOs and bodies who worked, and I think several have been mentioned, including, of course, Civitas Maxima has had a strong role in the, if not just the Saint Abré case, many cases. And that was a really unique point, as you said, sort of a watershed moment to move from. But you can see NGOs trying to pull these resources and get them together. But we might need something a little bit, and this is my thought, centralized on this to make universal jurisdiction a little bit more fluid across jurisdictions. And some of the challenges that we've been asked to raise, and I have several, so bear with. Some of the challenges we need to look at to perfect this have been already named, but number one is consistency. That's the number one all discussed here on the panel today. What are the definition of crimes? For example, the ICC says you can use ordinary definition of crimes, like murder. But what is the definition of murder, and are we remaining consistent? Or is it just adding those chapeau elements of war crimes, crimes against humanity, to make it something that falls under universal jurisdiction? There is, and I'm sure it was mentioned this morning, I see Mark Ellis here, there are some implementing guides that have been made by some very, very helpful institutions, such as the strengthening of the ICC and Rome Statute System Guide for States Parties, which is really helpful in helping the states to actually implement consistent laws across the board and consistent processes that will really help to make this across all states and trials something that we see consistency in. Though there's still obviously room for impunity gaps where we don't have necessarily certain laws on the books in certain places. And then, of course, my pet issue would be, what are the standards of fair trial? And we've talked about fair trial rights. All of you, thank you so much for raising fair trial rights. I think this is pretty important. It was discussed earlier, actually, on a panel by Dr. Sedman and Lennart as well. You know, what are the bright lines? We have the bright lines of human rights instruments, such as right to counsel, right to translation. But what do those mean? Because we litigate those at the ICC and in the ad hoc tribunals all the time. What does it mean to have translation? You know, which documents don't fall under that? What is proper notice of charges? What does that actually mean? How specific? When does it have to actually arrive? And is that translated? And how is it translated? There's so much there that is not just the bald right that's, you know, encapsulated, but something that's really been fleshed out in the jurisprudence of, in particular, the ad hoc tribunals, the hybrid tribunals, and in the ICC, that I think needs to be translated in itself across jurisdictions to make sure that we're having the same consistent standards provided for the defendants who are coming before the cases. Another information sharing point there that we've talked about, how are the courts and tribunals domestically sharing, not just with the ICC and ad hocs, but with each other? This is something that also came up in the independent expert report about sharing information and how it could be done to better affect positive complementarity. But if we're talking about a trial that's going on in France, but there's also an equal trial going on in Côte d'Ivoire, or investigations in particular at the same time, how is that information sharing going on? And how can we make that a consistent or a more centralized process? So there's not duplicate efforts, but also not contradictory efforts too. Should there be databases? It's hard enough to find a case in a domestic jurisdiction anyway, sometimes when you get the one case and you can't find it. How are we going to centralize those resources, the filings, the jurisprudence that's emerging from universal jurisdiction cases? Because I'm very interested in it. In tuning in today, I hear these cases. I want to find them all. How do I find them all? And then when I do find them, do they have them in a language that I can understand, at least read? That is also critical because especially you look to some of the jurisprudence that comes out of the human rights courts too. You have to make sure that you have the right language skills in your arsenal to make sure that you can incorporate it into your litigation. Now, here's my pet cause that I'm going to have to put out here, but ne bis in idem. Ne bis in idem came up, of course, in the UNWCCC. We see that. However, we still face issues with it today because there really isn't, as far as the legal pluralism that's created within the international courts and tribunals and domestic and universal jurisdiction, there's not a consistent definition of what we're looking at with ne bis in idem. And we've seen this, for example, at the trials of the former Yugoslavia at the ICTY. You could have a case, it was a huge case, but it was whittled down into certain incident sites so that it didn't take 30 years to try. They left some of the sites out. Well, now can one of the war crimes chambers of the domestic courts, whether it's Croatia, Serbia, Bosnia, can they now try that incident later? And then the defendant is put into trials in perpetuity through the remainder of life because these are widespread and systematic cases. There's a lot that gets left out. So we have to do better on a definition globally about what we mean about ne bis in idem when we're trying these cases. Otherwise, we put defendants through never-ending trials. We put victims into hope of seeing, you know, we're talking about not getting relief for their specific crimes. We have to manage expectations by definition there, I think, for the ne bis in idem. And it also has to respect those cases that come out to be acquittals. You know, if we're going to allow these cases to be tried in universal jurisdiction, we have to allow for all outcomes, presuming that they were done under fair and proper processes. Again, the human rights court or lack of came up. You know, there are some places, if you're tried in Germany in a case, you may have avenues to go to the ECHR if you have a human rights violation that comes up, a fair trial violation that comes up in your case, or maybe you were tortured en route to get to Germany. But if you're tried in another country that doesn't have access to a human rights court, then you're at a disadvantage. And this goes to discussions of should there be some sort of overarching international human rights court to deal with all of this or to connect all of the existing human rights courts, or what avenue can we provide to persons who don't necessarily have it because they were tried by X state. And minimally, I think the human rights instruments came up. Thank you for that, Ms. Statewell. But the UN Declaration on Human Rights had a birthday a few years ago at 70 years old. And it needs a little bit more than a party, maybe. It might need a little bit more of a reaffirmation of the states, especially those who signed on to the Rome Statute, to say this is what it really means when we talk about fair trials. And here's what we really want to commit to. And looking at some of the jurisprudence and making that declaration might help in the context of universal jurisdiction exercise. Sentencing was talked about, but also lack of custodial equivalence. It's very different to be in custody in one country versus another. And there's a problem in the purpose of punishment in international criminal law. Why are we punishing people? Is it just retribution only? Because then it really doesn't matter that much about the detention situation. But if we're talking about rehabilitation, what kinds of programs are we going to be able to offer on a universal international level for people who have been convicted of war crimes or crimes against humanity? And that's for all the psychologists out there, people interested in this, maybe to start some kind of program that could be then implemented and used, because we already have this, of course, with persons from the ad hoc tribunals serving their sentences in different states, for example. So rehabilitation, if it's a goal of the community, we have to find a way to do it under this as well. And all of this can then, of course, lead to jurisdiction, forum shopping. You could have extradition requests of people who want to be tried in another location because something seems preferable. And these will take time, and justice delayed is justice denied. So who's going to guide this when there are these extradition requests that are taking time, and it's potentially something that is not neither state's giving up? Who's in charge of that? Are we going to the ICJ with these things? Where are we actually going to be on an extradition fight? Lack of reparation schemes or tie-in to one can be disparate. You know, the victims in one country may not have any access to a reparations scheme. In another country, you know, because someone was tried there might be. And there's varying participation models for victims across countries as well that maybe needs to be shored up for universal jurisdiction. And as was talked about as well, protective measures. The relocation, I think Dr. Beku had mentioned, is that even possible? The costs, some states will be at a disadvantage. They're not able to exercise universal jurisdiction because they simply don't have the ability to do it financially. And investigations was talked about, access, MOUs, subpoenas, summons. Does that mean though that we go to more video link? Because then, in my opinion, you know, you do lose something as far as your ability to ensure fair proceedings for the defendant. Others would disagree on that, of course. And then the historical record, which got touched upon as well by both of my panelists, you know, the truth-telling and accounting. There have been difficulties already faced at the ad hocs, and this will only be proliferated if we have, you know, a sort of an advent of universal jurisdiction across the board. There's potential for disparate findings about the history of what's happened, because in an individual criminal responsibility case, only the individual criminal who is allegedly responsible is interested. So in particular, when we look at guilty pleas, if those are allowed, then typically you'll see a narrative written. The person will look at it, of course, but every detail they might not even know. It goes into the record, and then what can happen is that can translate into adjudicated facts or agreed facts in other cases, in other jurisdictions, in universal jurisdiction. And then you might have a contrary finding somewhere else. Then you have, as far as the truth-telling narrative, the accounting, the historical record can be quite fractious all over the place, and maybe inconsistent. And that could also do some damage while trying to do good. That's enough of problems, though. There are a couple benefits. Done as a network, of course, it can ensure consistent standards, transparency judgments, as was asked here. The judiciary involved can help define customary international law faster, because we have so few cases right now at the ICC and in international criminal law that it is a slow pace to know what are the bright lines, because we have an outlawed war. So what are the lines of war that people have to be working within? It would be better to have more cases run through to have better idea of what are war crimes, what are crimes against humanity, which are much easier to define, of course. But what, you know, where are we, you know, in the wrong in all of this very clearly, and having more cases will definitely proliferate the jurisprudence. And it will also, of course, allow for more prosecutions. Those lower level crimes, we can't be doing them with the ICC. It's not just about whether it's proper or not, but it's expensive. It's a very expensive model at the ICC. And to run the cases of, you know, the most junior of soldiers through the ICC is not the best use of the world's money, and has the advantage to, if those people are maybe tried even closer to home, because we have all kinds of issues too of people being moved around. So there's a lot of benefits to it, but there's a lot of challenges we just have to sort out before we really start pushing the envelope on all of it. So thank you very much.
Marie, thank you for that. That was excellent. Also very, very interesting. Big thank you to all three of our panelists. I'd like to open the floor now for anyone who has any questions. Feel free to ask it to a specific or an individual member of the panel, or you can simply ask a question and field it to any of the panelists who may wish to offer an answer. Does anyone have any questions? Yes, Amina.
Thank you to all three panelists for that really interesting, those really interesting presentations. So I have a couple of questions. I have a question for all the panelists, and then a particular question for Tatiana and for Olympia. So the first question to all panelists, I was wondering, what do you, like, one of the challenges that was touched on in all the presentations was the lack of uniformity of law providing for universal jurisdiction between countries. And I was wondering, how useful do you reckon that the ongoing discussions in the UN General Assembly, so for the past number of years, the UN General Assembly has been looking at the question of the scope and application of universal jurisdiction. And I was wondering, do you reckon that that might be a useful forum to try and hone in on guidance or some sort of instructions for states to better implement uniform universal jurisdiction laws? So that's to all panelists. And then for Tatiana, I was wondering, so you mentioned this initiative that is going on at the moment to try and pool countries' jurisdiction into some sort of forum where they would prosecute, I think it's crimes committed in Syria. I'm not 100% sure. That's just from what I gathered from what you said. But I was just wondering if you could elaborate a bit more on that, the proposals for countries to pool their jurisdiction into one forum where those atrocity crimes could be prosecuted. And then lastly, for Tatiana, I was wondering just your point about universal jurisdiction over genocide. And obviously the Genocide Convention doesn't provide for universal jurisdiction over genocide explicitly in the treaty, but and then there is this belief amongst scholars that, oh, it's in customary international law. And I have a real problem with that assumption, because I think if you look to the two-pronged traditional test of the components of customary international law, so opinio juris and state practice, it's questionable as to whether or not there is enough of those requirements, have those standards been met in respect of universal jurisdiction over genocide, because there's just so few cases to point to in that area, which makes it really difficult to try and pinpoint a definitive rule on customary international law. So I just was wondering, how do you approach that conundrum in terms of how do we pinpoint where universal jurisdiction over genocide exists? That's something that I'm really interested in, and I've written a bit on that. I've got an article coming out in the Journal of International Criminal Justice where I try to argue that, well, there's not enough state practice or opinio juris. Well, there may be opinio juris, but there's certainly not enough state practice. But that doesn't stop states from exercising the jurisdiction over genocide, and that is a fact. It's happening. It doesn't happen very often, but it is happening. So I was just wondering, what approach do you take to that conundrum yourself? And thanks to all speakers.
So shall I go first? I was waiting for Lennart to. Okay, so thanks very much, Amina, for those questions. The first question, which was to all of us, is whether the current discussions before the UN General Assembly on universal jurisdiction are useful. I think they are, and I think it is very useful to have multiple fora looking at these questions and keeping the discussion going. For example, the ILC, is also looking at some of this, as you may be familiar as well. of course, what will come out of it and how useful it would be, it remains to be seen, you know, in practical terms. I think having the debate is very important, but I think, although I obviously get how hard it is in practice, I was thinking as my colleagues were speaking, and I share very, very much of what you've said. I think we probably have a panel where we all agree with each other here. That I was thinking, why are we treating those crimes differently to any of the other crimes? You know, proliferation of international law is happening in every area. Fragmentation of international law is happening in every area. Why? I can see the need for clarity and consistency and coherence and the risks of foreign shopping, but I'm not sure we can so neatly fit everything together easily. And maybe, yes, more coordination, definitely. And I think that work by the UN General Assembly might help spur that sort of information sharing a bit more. But I don't have particularly strong views as to whether that might be useful in practice or not. I think for me, it's a bit early to tell, but I follow it with great interest. I think the question to me was the possibility to pool universal jurisdiction for Syria. I thought you were asking me. This has been an idea that has been floated by both academics. Beth van Schaak, for example, has written on these areas, but also some initiatives by, I believe, the Netherlands. Sweden have also, if I'm not mistaken, had discussed this possibility in terms of an ISIS-focused tribunal outside Syria. Obviously, there has also been the work of OSJI in particular on these issues. So NGOs are also looking at this sort of area. Obviously, it's not so easy. You know, we have the classic questions of, even if we pull jurisdiction, you know, what does this tribunal look like? Where will it be located? How do you transfer evidence? What are the, you know, what is the structure? Do you include internationals? What timeline? How far back you go? You know, what do you cover? Where is the beginning of the Syrian conflict? Is it the Daraa teenagers, or is it somewhere else? You know, so these questions are very, very difficult to answer unless we have a particular roadmap and the commitment to create such a tribunal. So, but there are more fundamental questions in terms of what is the court's purpose? What are we trying to achieve? If it's narrower, it might be easier to set up. If it's wider, then you know, it's harder to establish. A tribunal which is parachuted in without a genuine Syrian participation might have legitimacy concerns. So yes, it has been described as a new Nuremberg moment, that we perhaps revisit, you know, the pooling of jurisdiction as one way of creating Nuremberg, and we apply it here. However, we don't want to be selective. We don't want to be cut off from the reality on the ground, and it might be hard to achieve. Thank you.
I may as well go next as number two. I'm afraid I can't. I follow Professor Becker in respect to the General Assembly's discussions on this. With respect to there being some uniformity in the law providing for universal jurisdiction, I think really the International Law Commission is a very important institution in this respect, and their reports are certainly of great influence. But really, I think the Rome Statute itself, as an international agreement, is an important one in terms of definition of the crimes that we sort of in public discourse and people generally consider to be crimes of universal jurisdiction, even if legally they're not, which brings me to the second question with respect to the Genocide Convention and whether or not genocide is in fact a crime of universal jurisdiction. I really look forward to reading your paper. I will read it with great interest. I think this is a difficult conundrum. It's one that the European Court of human rights faced with respect to an Article 7 application. I think it's Jorgik in Germany, and found that there was sufficient practice to, or sufficient authority for it to be considered. Well, they weren't specifically talking about crime of universal jurisdiction actually, but for genocide to have been crime at the time it was committed under customary international law. There have been, I thank Professor Dan Plesch for the comment. There have been some trials of genocide. And I think really, if there were to be a challenge, if there were to be a prosecution brought, and that the legislation of the state to be challenged on the basis the state doesn't have the authority to exercise universal jurisdiction, then that will be the place where it's fought out. But for now, that hasn't really, as far in my knowledge, been a concern, certainly in the United Kingdom, because legislation doesn't provide for it. And that's not much of an answer, I'm afraid. I think it is a conundrum. I think identifying customary international law is incredibly difficult, and the practice is there's somewhat a dearth of practice by virtue of states being unwilling to bring prosecutions for genocide. But there are states that have a far broader extraterritorial jurisdictional reach over the crime than the United Kingdom, of where I'm qualified, and those prosecutions have continued and gone ahead. So I think that the obstacles to it, to a state exerting its jurisdiction over the crime, are pretty low. I'd be really interested to read your article, though. I'm afraid I think you're probably more authority than I on the topic.
I don't know about that, Tatiana.
No, I think you.
Thank you.
I'll just, if I can just chime in just really quickly on this last, I mean, just to emphasize everything that's been said there, and the ILC's work, especially on crimes against humanity, which are a little bit thornier as far as figuring them out. Where possible, having things agreed by states and written down where possible is always preferred to know, instead of trying to read out what the customary international law might be through cases. So efforts like that, I think, are very useful, at least at the practitioner end.
Thank you. We have a question from Mark Ellis next.
Thanks very much. What a great panel, I thought. And Lennart, great to put those questions up. I had a more generic question for the entire panel that deals more with a political issue. Olympia started the conversation, I think rightfully so, saying that, well, the absolute form of universal jurisdiction clearly has been in retreat for a long time. And so this conditionality has been placed in most universal jurisdiction laws, as we know. But I want to ask you, when this happened, it seems like it was meant to bifurcate the use of universal jurisdiction, so it could be used for not the developed countries, but crimes are committed or perpetrators coming from developing countries. So you kind of bifurcated it, and you created. I'm asking whether we've created something that says, well, listen, the powerful can escape accountability, the powerless cannot. And universal jurisdiction is actually feeding into this. And even when some of the countries, whether it was Belgium, Germany, the UK, Spain, attempted to focus universal jurisdiction on developed countries, on the powerful, they quickly changed their tune because of the aggressive action, particularly from the United States and others. So when we're talking about universal jurisdiction, do we have to always keep that in mind, that we're creating it's a good concept, good principle, I certainly support it, but aren't we creating two separate paths here? And universal jurisdiction, as it grows, certainly is being used effectively, but not towards the powerful countries. We're not seeing, I don't think I can point to any case at all that has been directed in that successfully been directed in that case. So I'd just like your thoughts on that.
What a thought-provoking question, this one. I'm not sure how I can answer it, Mark. I think you're right. We saw if I remember back, it was 2003, wasn't it, with Belgium trying to bring prosecution of Ariel Sharon and Shabra and Shatila and General Tommy Franks, and then suddenly, you know, the US throws its weight on Belgium, threatening to move NATO headquarters to Frankfurt and all of that. So suddenly we see a change on the universal jurisdiction to, you know, to have a not a pure form of universal jurisdiction, but require presence and all of that. I must admit, I haven't thought about it in those terms, but I think if we were to make a sort of a political comment, it might be that, you know, then Germany and everybody else changing their laws to allow for some of this link that essentially you might go against the whole principle of universal jurisdiction in a bit. But let us not forget that Pinochet ended up in the UK on the back of a universal jurisdiction case, right? So I don't know if that's just a pragmatic view that you need to have some link in order to have better evidence, or whether it's simply the politics of the bifurcation that you alluded to. I'm not sure. Thanks.
To keep the order, Marie, I don't know if you want to come. I'm just keeping the order of the panel. I'm not, don't want to assume anything. I think it's also a really interesting question, because in my mind, universal jurisdiction was conceived of in order to ensure the powerful are prosecuted and do not enjoy impunity for the crime of torture. And in terms of the Geneva Conventions, the universal jurisdiction regime, it's arguable, was there only with respect to the grave breaches. And that again is the powerful. It's you know, an international armed conflict. It's two states. It's arguable that it would only be with respect to the belligerents in the conflict, with respect to any obligation to prosecute the grave breaches regime. But again, it's sort of I think its initial conception was about bringing the powerful to justice. And I find it's a very thought-provoking question. I think it's the way in which, the sad way in which our the realpolitik, I guess, of international criminal justice, and you see it with the ICC and the struggles it's go through, that the powerful are very quick to condemn investigation of their own and to condemn those who would deem to investigate the powerful, and indeed take steps within their own jurisdictions to ensure that investigations aren't conducted. So whereas this is universal jurisdiction I think is a potentially positive thing, and there are positive things. It's really grateful to Marie OLeary for mentioning the investigative mechanisms. I think they're very positive developments in international criminal justice, and the documentation and collection of evidence that can be used later on in the prosecution of atrocity crime. We are seeing a lot of pushback in that respect, certainly within the United Kingdom, and within the international community as a whole with respect to the whole project. So there's a sort of interesting tension there. Sorry, Marie, that's me.
I'll just join in what everyone has said. No, it's a very tricky question to talk about. You know, how politics can influence. I think that there is something there when I mentioned cost. You know, even if you are, you know, even if you leave politics outside of it, there's some countries that are simply just not able to do it, not able to try things themselves, even if they want to, because they simply don't have the infrastructure or resources to do so. And that's also part of the power dynamic that you'll see between some states able to do it, have the ability to do this, and others don't, so that you can see the arm of politics can be put through there, of course. But I mean, again, is there you keep thinking about, is there a centralization, or is there a way to mutualize resources? When we talk about this kind of came up, you know, or whether there's a way to centralize it and make it more universal, truly universal and universal jurisdiction. But then that's where we get back to, I think that's why the ICC is there, and people are supposed to sign on, you know, as a collective to sort of make some of those determinations and have the complementarity that flows through that. But I'll just leave it at that. Thank you.
Thank you, everyone. We have one question in the chat from Kathleen Fingleton, and afterwards, Dan Flesch will have one as well. I'll just read out the question from Kathleen. Everyone has brought up the ongoing problem of common or harmonized definitions. Isn't that an even more knotty issue when it comes to prosecuting destruction of culture, as referred to in panel E? Whom among the panel would like to volunteer to answer that question?
Well, I can have a go, even though I'm afraid I haven't followed the discussion in panel E, so maybe what I'm saying may not be relevant to your question. I think, as someone who has spent the past 20 years looking at implementing legislation, and I've got a database that coordinates all the implementing legislation, part of the ICC's Legal Tools project, I can say that every crime is actually problematic when it comes to definitions, and you can find widely different definitions of domestic implementation of the crimes. Okay, yes, cultural destruction of cultural property. As far as the ICC statute is concerned, I don't think is a particularly problematic crime to implement, as far as I can recall off the top of my head. But there are all sorts of, you know, even if you take genocide, even if you take you know, protected groups or whatever, you'll find states that go above and beyond the Rome Statute. I don't think that's necessarily bad, but you could have arguments that this dilutes the definition and so on and so forth. So we can have that whole discussion across every aspect of the implementation. And you know, we refer to a lot on implementation, so I thought to bring that up, that essentially it varies a lot. And we don't have a mandate. Remember, we don't have a mandate to harmonize. We have a mandate in some instruments, not the Rome Statute, to implement. In the Rome Statute, we only have an obligation to implement cooperation, not the crimes. And that leads to different approaches taken. And you know, I think that plurality is perhaps a way to try and link to the previous political question, is perhaps a way to ensure that states sign up to things. It's not, if we were demanding uniformity, I think we would have seen fewer states signing up to the International Criminal Court, perhaps.
Thank you. In the interest of time, we'll leave that question there. Professor Dan Flesch, you have a question.
A comment on the question of powerful impunity and torture. I've written a little bit about this in the blogosphere, but I just found it startling that although water torture was part of the indictments in Tokyo and was routinely prosecuted successfully by US military tribunals in hundreds of cases in the Far East and its equivalents in Germany. There's no recognition of this in the critiques of post 9/11 water torture that I've ever come across. And this, whether this is self-policing or blindness or amnesia, I'm neither a psychotherapist nor a historiographer. But for those of us interested in the political sphere, I find it at the politest startling. And to this day, I mean, Richard Goldstone, when he was visiting at the Legal Prosecutors University in Virginia, tried to get them to the JAG University in Virginia, tried to get them interested in the hundreds of cases of which the full trial transcripts exist on our website, and now thanks to the work we did with the UN on legal tools of these military tribunal cases. But no American law school has taken them up. And I've come across no scholar since it's now 5 years, 4 or 5 years since we made these available, and I've yet to find, a doctoral student or anybody looking at them, and it kind of slightly defeats what I thought the structure of academia was. You make ideas and information available, and people read it and make use of it, and then possibly things change. But this wholesale blanking of America's own legal context in prosecuting these issues is something I'd be interested in what other people think about, because it's clearly, whatever the motivation, the result is endorsing American impunity for its own actions when its own conduct condemns it. In past conduct condemned its current actions. If that made sense.
It's a very interesting question. Thanks, thanks, Dan. Who would like to go first on that one? Someone better put their hands up, or I'll pick one of you. Right, Tatiana, do you want to have a go?
Well, I probably have to make a confession that I was really ignorant about the War Crimes Commission and the prosecutions. And have been involved in a couple of cases involving torture. But then, of course, I haven't been, I've been defending the person accused. I think it's a really interesting point. I think there's a lot of willful blindness on the part of states and governments with respect to their own involvement in war crimes. The Second World War is a great example of it, Dresden. And I simply don't know the answer. I think it's incredibly interesting. I would urge you to publicize the fact and push it more to the forefront.
I did 3 or 4 blogs. I did 3 or 4 blogs on the subject, and worked with various American international criminal lawyers. And if Richard Goldstone can't move the JAG, look at its own prosecutions. I wonder quite what a mountain there is. But I do find it remarkable, and that's the politest word I can use. America appear to be awash with highly critical international criminal legal experts, and yet there's no discernible picking up of this. And there are other sort of what I might call judo issues, or flipping strength against them, because Senator McCarthy started his career by getting SS men who had demonstrably slaughtered GIs, prisoners during the Battle of the Bulge. He started his career getting these SS men released from prison, arguing that they had been wrongfully convicted because they had been maltreated in jail by the Americans. If I did a blog on that, no bounce. So whichever way you look at it, I mean, there is a very powerful set of issues coming from American conduct in World War II. And in Germany, American prosecutors, the JAG went around, based upon intelligence reports of what happened to their flyers, finding out what happened to aircrew who were under Hitler's orders murdered when captured. I have to say, I slightly disagree about Dresden. My mother was blown up by a V2 in Soho 6 weeks after Dresden. The idea that the war was over and the Germans had given up at this point, I think, is entirely untrue. And that tends to be the argument against the cessation of mass bombing at that time. But anyway, I don't want to go down that path, but I'm channeling my late mother in that respect, because she had decided views on that question.
I was mentioning it more as an example, not to get into that argument, but how the Allies themselves committed many war crimes as we see them today, and do indeed in current conflicts. And I guess it may be quite simplistic, but goes back to Victor's justice and these kind of ideas. Yeah. I'd be really interested. I would personally be very grateful if you have the time to send me to the links to your blogs, because I'll be very interested to read them and draw upon them if I may.
And all the, if you have an intern or something, all the American trial transcripts, apart from being on Legal Tools, where it's a bit more cumbersome, they are on our website, and they're all immediately digitally searchable. You just got to put in, well, they called it the water treatment in those days, but you only got to put in water treatment into the American trial transcripts as a search term, and they all come bounding out at you.
Right, well, thanks, Dan. That was clearly extremely interesting and something which is food for thought for all of us. I think, if Amina agrees, we've reached the end of our time, which leaves me only to say thank you so much to our amazing panel. I think it was a fantastic and thought-provoking discussion that we've had today. Thank you for everyone who's tuned in and asked questions and otherwise just listened. And I know I've certainly learned a lot. I thought I knew a lot about universal jurisdiction before I came onto this panel. Clearly, I'm not as knowledgeable as I thought. But all the more reason for having panelists and speakers like this join us. Thank you again so much for everyone, especially the speakers, the panelists, Maria OLeary, Tatiana Eatwell, and Professor Olympia Beckow. Thank you very much.
Thank you very much, Lennart, and thank you for chairing that panel. So what I want to do now, just before we move on to the close of the conference, I'm sure everybody's zoomed out at this stage. I just want to take a group photo just for the funders to show that this event took place. So if you wouldn't mind, if you haven't already, just placing your camera on. I'll just take a quick snap. Okay, so 1, 2, 3. I'll just take another one for good measure. Now, 1, 2, 3. There we go.
Amina, you're on mute.
Sorry. Just to close to begin the end of the conference, thank you so much to all the presenters, so those who submitted abstracts and presented their research in this area, and those invited speakers who were so generous with their time and with their knowledge today. I'd like to thank each and every one of you, and all of the chairs for expert chairing today. I'd also like to thank on the admin side, Olga Fay in the Administrative Office in Maynooth University Law Department, who helped in organising this event, as well as the administrators today in each of the panels. So they were some of my fantastic LLM students. That's Mick Melia, Natasha Bradley Byrne, and Daniel Kaur. So thank you very much to them for organising this event, and also to Aisling Gormley for her help in organising the administrative side of this event as well. I'd also like to thank Professor Plesch for jointly organising this conference, and to Lennart Poulsen for organising the panel on universal jurisdiction this afternoon, which was stellar. And now I'll hand over to Dan, if you would like to add anything.
Well, it's been a fantastic day. I've learned a great deal. I think it's been really rich discussions. I really hugely appreciate Amina's initiative in organising this project over the last 6 months, and Lennart from Chambers in putting together this final panel. There are many strands to pull together. I just want 2 points. One, I put 2 of my blogs on America's record in the Second World War on prosecuting torture in the chat, so you can just copy them out before the chat finishes. I think Michael Fleming's examples about cultural crimes are indicative of how we can really use concrete precedent and practice from the 40s to reinforce efforts to develop new law and practice today, and maybe raise the question, if we just knew what we already had, we wouldn't have to invent something new again, as an example. And in general, I think a number of speakers have alluded to the point that whether it's East Timor or Lebanon or Syria, that there is a need, and Mark has written about this, for a UNWCC-like a coordinating function of support for national efforts. And if that's one takeaway point from this conference, I think reinforcing that idea, and I think I would very much welcome partnerships with any of the people here on others, as we discussed going along. There are still, I think, many seams of gold in this mineral field to be explored, of a real contemporary as well as historical relevance. So thanks again to everybody, and to Amina in particular. And now it's a great pleasure, I think, if I can, Amina, call upon Alanna O'Malley from Leiden, where she's chair of UN Studies, to give concluding remarks on the day's effort.
Yeah, thanks very much, Dan, and thanks to Amina as well for the invitation to weigh in a little bit on the kind of conference as a whole and on your discussions. I should say that I wasn't able to join for all of it, but I did manage to dip in and out to some of the panels, and I greatly enjoyed what I was hearing. You know, I'll be straight up, I'm not a lawyer and I'm not an expert in international criminal law, but I am a historian of the United Nations, particularly interested in forgotten pathways and the ways in which the organization forged and contested this idea of the construction of the liberal world order. And I think the War Crimes Commission is a particularly interesting missing link in that longer debate about the role of the UN in constructing global order across the latter half of the 20th century, and in particular providing avenues in this kind of rather broadly framed and kind of nebulously request for international justice. I think listening to some of the discussions today, a couple of key findings really emerged. And the most prominent one, and I think it comes straight out of also the last panel and the discussion about your universal jurisdiction, is that actually the historical precedent for a lot of the most contested principles of international criminal law is really existent in a lot of the War Crimes Commission's archives and in the discussions and the contestation between the 17 allied members. We know, of course, that the War Crimes Commission was also originally devoted to designing an international criminal justice system, in a sense, that would accompany the UN's other efforts in the areas of economic development and the preservation and promotion of human rights. And really what's really important about its role is that it really provided a multilateral agreement about the meaning of justice in one particular framework. And I think that that is something that has been a very long-lasting contribution that we quite inappropriately attribute to the whole debate about Nuremberg and the Tokyo trials and what happened in the persecution of the senior Nazi war criminals, rather than actually the kind of more, if you like, more scholarly debate that was going on within the framework of the War Crimes Commission. One of the issues, I suppose, that is also raised is this whole question of the legitimacy that the UN grants to this process when multilateral agreements are institutionalized, and when an organizational role is created for the UN. And there were some very interesting comments in the discussion there about universal jurisdiction, about how the organizational roles of the UN are actually developed in different regards. I mean, you referred very well to the debate about universal jurisdiction in the General Assembly, but we know, of course, that this was already mentioned and already introduced to the Economic and Social Council of the UN back in 1948 by the War Crimes Commission. So this is a kind of a long-lasting debate that is carried through the various organs of the UN. And so one of the questions that remains is really in thinking about how does the contestation of these different legal but also kind of principled ideas about international law in its various and wide guises, but also particularly in this case international criminal law, how is that affected, if at all, by its contestation in the various organs of the political side of the UN? And that was something that I think really underpinned a lot of the debates that we heard today as well, was this relationship between the politics and the principles of the UN system, and how actually in the case of the War Crimes Commission, it was the politics that really kind of won out on that debate quite a lot, particularly in its kind of early kind of foreclosure of the whole commission itself. And that was something that I think quite rightly needs further attention. I think this whole attention towards the War Crimes Commission and the longer roots of international criminal law. You know, we've been centered as historians a lot around the debate around the definition of genocide, around the role of people like Raphael Lemkin and Hersch Lauterpacht, and around that moment that Philip Sands has, you know, written so eloquently about. But I think what's interesting here is we're looking at a kind of a multilateral moment that occurs that's fundamental to the development of international criminal law, that's fundamental to the definition of crimes against humanity, that really actually precedes a lot of those later debates. And why is this important? Because the traditional narrative in this area is that it's the Western powers who engineer this whole system in an effort to construct liberal internationalism through the UN and its various guises. But actually, when we look at the workings and the content of what's going on at the War Crimes Commission, we see that, in fact, it's Western powers who act as the bulwarks against the face of concentrated agreements and efforts of other nations, but also really the rather global roots, rather than the Western roots of some of these ideas. And in fact, it's actually countries like India and Czechoslovakia and Poland who play a really formative role in the creation of the War Crimes Commission, and are really, you know, pressing various definitions of how to pursue Nazi war criminals in particular, but also how to define war crimes very generally. Unfortunately, I suppose the War Crimes Commission is confined to very narrow terms, so it's really only allowed to collect information on Axis crimes from the 17 Allied nations and to investigate breaches of the Fourth Hague Convention on the laws and customs of war. And this really, if you like, is quite a shame. So a lot of the precedents that we're hoping to highlight by some of these discussions are unfortunately, I think, limited in scope in terms of what the War Crimes Commission could do, but act as a kind of a useful conceptual basis in thinking about the kind of genealogy of some of those bigger ideas later. Just to kind of conclude very briefly, because I know you've been online at the conference all day long, and you know, there is a certain Zoom fatigue that sets in at the end of November, of course. I just wanted to highlight kind of a couple of, you know, kind of future frontiers that we might think about in taking forward some of these discussions. The first one, of course, is we really need to sharpen the focus on the contestation of the legal principles around the persecution of war crimes that actually, as I said, foreshadows the debate on the role of genocide. And this is really important because it will also tell us something more about the development of international law, you know, before the end of the Second World War, but also building on the ways in which these ideas were thought about in the interwar years. You know, not forgetting, of course, that this is not just begin, it's institutionalized with the War Crimes Commission, but the whole idea of international criminal justice does not just begin in 1941 and 1942. Secondly, a broader analysis of the longer term roots of liberal internationalism in the various UN organs, particularly pertaining to the development of international law, can be, I think, adequately analysed through a more sustained analysis of the role of the War Crimes Commission and its long-term impact, if any. And I think it's very important not to be too positivist in our views of this quite limited in scope and limited in breadth organisation. It's set up, of course, with 17 allied nations, but it's shut down fairly fast and fairly prematurely, primarily by the United States and the UK. So, I mean, does it really have a long-term impact on the institutionalization of some of these legal principles, or is it the political contestation around them within those documents that actually points to some longer, wider and bigger issues? I think what it does show us, and this is the last thing I'll say, and that again, this came out in a lot of your discussions this afternoon, is the role of the often unsung and deliberately muted actors in orchestrating and acting as architects of the international system in various different levels, including in the international system of international law, of course, rather than really considering them as only the recipients of those ideas. And that's certainly something that goes against the grain of general, I think, international legal history and thinking about that moment of the importance of the first War Crimes Commission, but also the first international criminal trials in the 1940s and into the early 1950s. So I think there's a lot of interesting work that we can draw out of the discussions today. I won't talk about the contemporary relevance because I think many of you have done that much better than I could. But I would say that historically, this is a really kind of missing link in the history of the UN. But it also, I think it's very important not to be too kind of hopeful either about the gems that we might find in these discussions, because I think what it will show us is the kind of balance and in fact the failure to balance politics and principle within the discussions about the contestation of the meaning of international criminal law at that time, which tells us something about the functioning of the UN system, but probably not something that is going to be incredibly positive and beneficial for the future development of these ideas. So thank you very much for giving me the chance to say a few words.